Smith to my left, and myself, Judge McClarty. I want to remind you that our proceeding this morning will be recorded on record, so you advise if it's not something you want to hear again, you might not want to say. But at any rate, the procedure as we start off with each party, I think we allow 15 minutes per side. The appellant has the time that they can reserve for their presentation and then to reserve rebuttal time. We do not usually allow more than half of that time for rebuttal. Madam Clerk, is there any preliminary matters that need to be considered before we start this morning?
No, Your Honor.
In that case, will you please call the first case?
Renee Nitter-Martin versus Methodist Healthcare-Memphis Hospitals.
Good morning, Your Honors. May it please the Court, my name is Davis Fry. I represent Quince Nursing and Rehabilitation Center. May I have 3 minutes at the conclusion to rebut the plaintiff's case, please?
3 minutes. Thank you.
Thank you, Your Honor. May it please the Court, this appeal relates to a valid and binding agreement to arbitrate the claims that are issued in this case. Somehow, in the case below, the concept of authenticity and authenticating a document has become conflated with the concept and the burden of proof necessary to prove a forgery. And that's exactly what the plaintiff is claiming in this case. What we have is an agreement that is a business record of Quince Nursing and Rehabilitation Center. There is no argument from the plaintiff that it is not a business record from Quince. There is no argument that it is not a record that was part of Ms. Rosie Nider's admission file at the nursing home. And there's an affidavit from the Director of Admissions that, although he does not specifically have memory of Ms. Rosie Nider, because he admitted numerous different residents to Quince Nursing and Rehabilitation Center, although he doesn't have a specific memory, his affidavit states that this is a document that he used, regularly presented to residents at the time that they were admitted. If they were competent and able to sign the agreement, he would sign the agreement at the same time as the resident. So there's not an issue that this is an authentic document from Quince Nursing and Rehabilitation Center. What the plaintiff does in this case, which is pretty clever, is to say, well, we don't know if that's Ms. Nider's signature. But what they're really doing is saying that this is a forged document. And they carry the burden of proof to establish a forgery. Let me explain. The plaintiff's argument is that
when you got a document that provides for the releasing or of a right guaranteed by the Constitution, should you not have some type of verification of that party actually signed that document, or whenever it's contested? If it had not been contested, things would have followed in line because you got a document there. But when that signature is contested, when you contesting such, when you're verifying, when the document verifying such a right with the magnitude of something violating that is granted in the Constitution, and the person who actually is presenting the signature, supposedly making the signature, when that person is at a state of being admitted to an assisted living facility or something of that nature, and by that very fact alone carries impairment, that person has some type of impairment, shouldn't that be, and I'm just asking the question, shouldn't that be some verification, whether it was notarized or even witnessed, to verify that person actually made that signature or on that document?
Your Honor, it's a great question, and it's one that the Supreme Court has said that arbitration agreements, while I agree with you, you are giving up a constitutional right, but arbitration agreements like this must be contract law applicable to all contracts must be applied here. What's happening is that there's a shift in the burden of proof. Your Honor, in order to enforce an arbitration agreement in this context, in the nursing home context, the nursing home must establish a prima facie case, and that includes a valid arbitration agreement and that the issue, the controversy, is within the scope of that agreement. By doing those two things, the nursing home has created a prima facie case of a valid and binding arbitration agreement. In response, the plaintiff in this case can come forward with evidence and say, I'm going to rebut that presumption, but it has to be competent summary judgment evidence. And in this case in particular, when you are claiming that's not an accurate signature, someone else wrote Ms. Rosie Nider's name here, that is a burden on the party seeking to avoid the enforcement of the agreement. That's what's getting confused here. The evidence in this case, and I want to be clear on this because the plaintiff has been very cautious in how they make these arguments. There is no statement I could find in any of the briefing that says that is not Rosie Nider's signature. There's no affidavit. The plaintiff in this case is Rosie Nider's own daughter. She did not submit an affidavit saying, that's not my mom's signature. No family member, no friend submitted an affidavit saying, that's not my mom's signature. And there was no expert looking at the signature to say, in my expert opinion, this is not Ms. Nider's signature.
Let me ask you, and you didn't call an expert to establish that it was her signature, did you?
No, sir, I sure didn't, Judge.
And prior to the hearing on the motion to enforce the arbitration agreement, you were aware that the other side was saying that does not appear to be that party's signature.
We did learn about that, Your Honor.
And
That's
knowing
right.
all of that, you chose not to call an expert to opine about whether or not that was her signature?
That's right, Judge, because that's not our burden. That's not our burden of proof.
Well, anytime you have a contract, you have to show that the other party signed the contract. How do you prove that here? How did you prove that?
In this case, we presented an authenticated contract, an arbitration agreement.
When you say authenticated?
Yes, sir.
Well, the rule talks about authentication is showing that the person signed it. How did you prove that?
So, Judge, to authenticate a record, you have to present evidence to show that the document is what you say it is. That's Rules of Evidence 901. That's what we've done. We have an affidavit from the admissions director that states, this is the document I would have presented if I remember it. He doesn't recall the specific event where Ms. Nider signed her name, but the burden of proving it's a forgery is not on us. The burden of proving that it was not Ms. Nider's signature is on the plaintiff in this case, and they have not presented any evidence to establish that it's not her signature. They've only made legal argument. Let me cite the Tennessee Court of Appeals, this court, in Alley versus Pro Real Estate Developments, 2000 Westlaw 192562. When a written instrument is challenged based on the allegation that an instrument is forged, the burden of proving the existence of a forgery is on the party seeking to invalidate the agreement. It is on the plaintiff in this case to establish that is not Ms. Nider's signature, and they have presented nothing but legal argument, no evidence, no affidavit, no expert to show that it wasn't not Ms. Nider's signature. In fact, as I said, nowhere in their briefing do they say that's not Ms. Nider's signature. They simply say, we don't know. That is the Lexon case. That's the case that we cite in our briefing. In Lexon, two indemnitors tried to get out of an indemnification agreement by submitting affidavits saying, I don't remember signing that document, or that doesn't look like my signature. The court said that's not enough. That's not carrying the burden of proving that it wasn't their signature. Also in the Lexon case, there was an affidavit from the indemnities company. It was an affidavit from an employee who was not at the signature, was not at the signing of the document. But the affidavit employee said, well, I wasn't there. This is the type of document that we use in these circumstances. And in that case, that affidavit was sufficient. And the court found that you couldn't avoid a valid and binding arbitration agreement simply by saying, or indemnification agreement, simply by saying, I don't remember, that may not be my signature. There must be proof of a forgery. And that is the allegation here. Although the plaintiff never uses the term forgery, the allegation is that someone other than Ms. Nitter wrote her name on the arbitration agreement. And there is simply no proof in this record to satisfy that burden.
Let me ask you, under Rule 901, can the trier of fact actually examine the various signatures and make a determination about whether or not that appears to be the signature of the party against whom you plan to enforce that agreement?
Your Honor, under 901, again, the standard is the document what it purports to be? In this case, no one's claiming it's not the arbitration agreement in Ms. Nitter's file. There's no statement that's saying, that's not it. There was another document. That was a falsified document. No, that was never in my mother's admission packet.
So in regard to my question about 901, can the trier of fact look at the various signatures and make a determination about whether or not that's a genuine signature of the party against whom you plan to impose this provision for arbitration?
Yes, Your Honor, certainly.
And did the trial judge do that here?
He did not do that here. He simply said that we did not fail to authenticate the document. He didn't say, and there was no finding of fact. He never said that signature is not Ms. Nitter's signature. He made it.
Did you look at the various documents that Ms. Nitter signed?
Yes, Your Honor, I did.
And do they appear to be consistent in your opinion?
I believe so, Your Honor. They're all variations of Ms. Nitter's signature. I believe they are. And this is the only agreement that the plaintiff is objecting to. This is the only agreement that they are claiming was somehow forged. Ms. Nitter received services under the admission agreement that she signed at Quince. She received benefits. She received payment from the government based on documents she signed at Quince. This was one of many different documents signed by Ms. Nitter. And again, if the plaintiff is taking the position that this was not her signature, that it is forged, it is the plaintiff's burden of proof, not Quince. And they have not provided any affirmative proof, any statement, any affidavit, any expert testimony that this was not the signature of Ms. Nitter, and they never even say that affirmatively in their briefing in this case.
And you presented no proof, in fact, that it was her signature. Your client didn't say that he recalls her signing, and also in the affidavit doesn't say that it is, in fact, her signature.
That's correct, Your Honor.
All right. Okay.
Thank you, Judge.
Thank you very much.
Thank you.
The appellee.
May it please the court, my name is Dina Arnold and I represent the appellee in this matter. This appeal arises from the presentation of an arbitration agreement appellant claims was signed by the decedent, Rosie Nitter, upon her first admission to Quince Nursing and Rehabilitation Center on September 17, 2021. The purported signature of Ms. Nitter on the jury trial waiver and arbitration agreement is unwitnessed, misspelled, bossy Nitter, undated, and does not match her signature on her Tennessee driver's license or on her self-authenticating Tennessee durable power of attorney. No competent witness testified that the signature on the agreement was in fact Rosie Nitter's. Ms. Nitter would remain a resident at the Quince facility until November 2nd, 2021. 129 days later, on March 11, 2022, Ms. Nitter was admitted to appellant's facility for a second stay. No arbitration agreement was executed for that stay. Appellee's claims arise out of both individual stays. This appeal presents an opportunity for this court to confirm that to meet its initial burden to prove that a valid and enforceable agreement to arbitrate exists, a party must first authenticate that agreement. Is it enough for a party to simply attach a document to a pleading for the burden to shift? Long-standing Tennessee law says it does not. Here, the trial court properly and correctly found that appellant failed to satisfy its initial burden to authenticate the agreement under the rules of evidence, thereby pretermitting any other discussion whether or not that agreement was otherwise enforceable and valid. The standard of review in this case is actually twofold. Because the trial court's decision relates to an evidentiary matter, an abuse of discretion standard applies, as it would with any other evidentiary issue. While appellant would like this court to apply a de novo review to the trial court's evidentiary findings, a de novo review only applies to the actual denial or granting of the motion to compel arbitration. This exact same approach was applied by the reported decision of Lexon versus Windhaven Shores, where the authenticity of a contract, just like here, was at issue. Long-standing state and federal law clearly mandate that arbitration agreements are to be treated just like all other contracts, which would include treating this contract just like the indemnity contract in Lexon, where authenticity was the threshold issue. So where authenticity is at issue, which to my knowledge has not been addressed by the Tennessee appellate courts, in the setting with a motion to compel arbitration, the trial court, though, first must decide this gateway evidentiary issue like it would with any other contract. And that decision is reviewed under an abuse of discretion standard.
Let me ask you, looking at the order, has the judge said enough for us to conduct a review? The order just simply says authentication has not been proven, but doesn't set any details as required by Rule 52. What do we do with that?
Your Honor, I do think the order was enough detail by saying it's not the agreement had not been authenticated. The trial judge was saying that the document is not what it purports to be, and when you have a writing, you have to prove, with a signature, you have to prove that the signature is in fact authentic.
And so what do we know about what the trial judge was looking at to make that determination?
Well, we have the record before Your Honors and before this court, and what we have is the actual document. We have the Tennessee Durable Power of Attorney Act, which was in evidence, which showed that document was actually signed by two witnesses and notarized, and that signature looks completely different than the signatures on all the documents that appellant is saying that Ms. Snyder signed. And when you compare those two, as Your Honor correctly found, the trial court can make the determination on its own whether, just by looking at the signatures, whether or not that signature was in fact Ms. Snyder's. And the trial court had all that information in front of it and correctly found that they had not met their initial burden.
So, go right ahead. I'm sorry.
But what about the order that the trial court presented to us? Are we to go back and review what the proof that was presented, or review based upon what the trial court actually made a decision on? And how are we to know that if the trial court hasn't given us the guideline as to what they based their decision, what it based its decision on?
Well, the trial court said, I do not find that it has been properly authenticated, and that standard is an abuse of discretion standard. So unless Your Honors find that the trial court abused his discretion in making that evidentiary finding, his decision must be upheld. He found that they had not authenticated the agreement based on the evidence before it.
Well, without knowing more, did the trial judge say anything at all about, it appears from his review that the signature on the durable power of attorney is Ms. Nider's signature, because that was actually witnessed and notarized, but we don't have any of that. And we know from looking at that, it's very different from the signature on the proposed arbitration agreement. But the trial judge doesn't tell us any of that.
I will agree that's not in his order, but it was in the transcripts that we do have, that are part of this record on appeal. It was something that the trial court clearly considered and was presented to him. And then in his order, I agree, it does not say that specific detail. But I think for your honors, you just have to determine whether or not it was an abuse of discretion based on the record and his order to find that it was not authentic in this situation. Which brings me to my next point. As your honors know, authentication for signed writings require proof of signing by the party to the writing, and writing standing alone is not evidence. The appellant must have come forth with some competent proof to show that this arbitration agreement is what it purports to be. From the outset, all appellant ever did was attach to this motion to compel arbitration a document with no supporting affidavit from a custodian of records to say that this record was kept within the regular course of the business activity, or an affidavit with competent personal knowledge stating that this was in fact the signature. And a writing standing alone is not evidence. After that, appellant took no further action to support their motion. Later, the testimony of Mr. Smith was procured, but it was at our request. And in Mr. Smith's sworn deposition testimony, it became apparent that he could not authenticate the agreement. He testified he could not say for certain whether or not the signatures on the documents were Ms. Nider's. Appellant's counsel at the hearing, May 28, 2024, conceded Mr. Smith cannot say that the signature is in fact Ms. Nider's.
I'm sorry, what did you say the date of the hearing was?
May 28, 2024?
And the affidavit of Mr. Smith was signed on May 21st?
Yes.
So right before the hearing, but almost a year after, or some month, October to May, whatever that is. Don't
Yes.
ask me to do math. That's the distance between, or the gap of time between the deposition and the affidavit?
Yes, Your Honor.
Okay.
Yes, and in that affidavit, after his sworn testimony many months before, appellant had Mr. Smith sign it. We moved to strike it in an attempt to cure that authentication problem. And in that affidavit, he then says, to the best of my knowledge and belief, she did sign the arbitration agreement. That affidavit is directly contradictory to his sworn deposition testimony, and Tennessee follows the rule that contradictory statements by the same witness regarding a single fact cancel each other out, and they are not evidence.
Well, I want to ask you, I'm sorry to ask you such a specific question. I haven't had an opportunity to read the entire record. I've read the briefs, of course. But in the affidavit, this says, I personally wrote Rosie Nider on the arbitration agreement and placed an X on the line for her signature. Does his deposition speak to specifically remembering writing that?
I don't believe his deposition talks about that. I think what his deposition says is, I don't remember meeting with Ms. Nider. I don't remember this interaction. I can't tell you where or when this interaction occurred. He couldn't give any details about this interaction at all. And so he could not give any of that information.
But the affidavit reflects that he then did remember this personal interaction some months after his, some months after his
Yes,
deposition.
his affidavit is contradictory to his sworn testimony. His affidavit also shows that his standard practices were not followed. When you compare the affidavit to the documents to his sworn testimony, it shows that standard practices were not followed such that you could infer personal knowledge for Mr. Smith to have known that she signed this agreement. And I'll give you the examples. Mr. Smith presented an Alabama admissions agreement for this Tennessee facility. The first page on the admissions agreement is not filled out with a date or who the parties to the agreement are. There's no actual signature on the signature line of the admissions agreement for the resident. And this is key. The arbitration agreement invokes the Alabama Rules of Civil Procedure, the Alabama Rules of Evidence, and the Alabama Medical Malpractice Act for claims pertaining to this Tennessee facility. This is highly unusual practice for appellant and its sister facilities. Their admissions documents have been the source of many state and federal district court opinions in this state, in the state of Tennessee. And not in one of those opinions, not in this court's opinion, in Jones versus Allenbrook, Edwards versus Allenbrook, or the Western District Court's opinions in Crawford, Denton, Hardaway, and Sykes, just to name a few, has there ever been any reference to the Alabama Rules of Civil Procedure, the Alabama Rules of Evidence, or Alabama law. This shows that standard practices were not followed in this case. What's more is that her name is misspelled. Her initials, the initials on the pages 1 through 3 are not hers. The resident's signature on the release of Medicaid funds is supposed to be notarized. It was not notarized. And finally, Mr. Smith followed his standard practices. There should be a new admissions document for her May of 2022 admission, and there is not.
Did you raise that argument below?
Yes, and it was predetermined by the court's finding that the agreement was not authenticated in the first place. So what the trial court was left was unreliable proof in this case. From Mr. Smith's testimony that he had no memory of anything, along with a signature that's not notarized, not witnessed, doesn't match the self-authenticating document. Without competent proof, there was no authenticated document, and the trial court was correct and did not abuse its discretion. Because the trial court found that appellant did not authenticate its document, it was never admitted into evidence, so the burden never shifted to appellee to prove anything, to prove a forgery, to prove anything, including that the agreement was in fact not signed by Ms. Nitter. Appellant failed to authenticate their own document. All they did was put a piece of paper and attach it to a pleading, never had competent custodian of records affidavit, which we commonly see in this nursing home context when you have a deceased person. You'll have a custodian say, this document was kept in the regular course of the business activity. Or we've seen in some other cases where you have the rep at the time of the signing sign a declaration saying, I saw them sign it and I was there and I witnessed it. We have none of that here. And it's a problem because a writing standing alone is not evidence. And without a properly admitted agreement to arbitrate into evidence, the trial court was correct in denying the motion to compel arbitration. Because both under the Tennessee Uniform Arbitration Act and the Federal Arbitration Act, you have to have an agreement to arbitrate in writing. So we submit that the trial court was correct. To the extent you disagree, we would ask for a remand back down to the trial court for the predetermined issues.
Below, did you cite any cases to support your argument that at the time of the second admission, it required the resident to execute a different arbitration agreement, a new arbitration agreement?
What we cited in the court below was Mr. Smith's testimony saying it was part of his standard practice that if the resident was out of the facility for more than 30 days, that's a new stay, new admissions document should be cited. We also cited case law regarding novation of agreements that once you replace or your standard practices are not followed and you replace a new obligation for an old one, the old one is no longer valid. So that was all fully briefed before the trial court, but he did not rule on it, finding the authentication issue dispositive.
And Ms. Snyder's readmission was more than 90 days after the initial discharge?
Yes, Your Honor. It was 129 days after her initial discharge. And it's not a readmission, it's a whole new, brand new stay because she had been out of the facility for so long. It wasn't that she just went to the hospital for 10 days or, 2 weeks. She was discharged and then had a whole second stay, and there is no arbitration agreement that has been presented that applies at all. to that stay. Any further questions?
I hear none. Thank you.
Thank you.
Your rebuttal?
May it please the court, to address the last questions first, the arbitration agreement that is in evidence in this case at paragraph 12 specifies that it terms, conditions, and consents are valid and binding upon the resident upon her readmission to the facility. And in the last sentence of paragraph 13 states, if it is not rescinded, the agreement shall remain in effect for all care and services rendered to the resident at the facility, even if the resident is discharged from the facility and readmitted later. So the terms of the arbitration agreement specifically apply to readmissions.
Forever?
Forever, until it's rescinded, It's
So-
an agreement that is always, the contract applies as long as it's not rescinded.
20 years later? it would still
Absolutely.
apply.
It's an agreement, and it should be treated like any contract.
What
Absolutely.
paragraph of that agreement were you reading
Paragraph
from?
12 and 13, Judge.
12 and 13?
Yes, Your Honor. Paragraph 12 is entitled Readmission Acknowledgement, and the last sentence in paragraph 13 indicating voluntary agreement. Also,
What about Mr. Smith's testimony that if the discharge for more than 90 days, then new agreements would be executed?
he said that is a typical procedure, that they do that, and he did testify to that at his deposition, and he said he wasn't certain why there wasn't a new admissions agreement and arbitration agreement signed later. So that was his testimony, he just didn't know. And to be clear, the affidavit of Mr. Jonathan Smith states specifically that he doesn't have a memory of Miss Nitter. This is not a situation where the affidavit is diametrically opposed to the testimony at the deposition. We have always taken the position that Mr. Smith just doesn't remember this event. What he can testify to is his own handwriting on the agreement. I wrote her name. I recognize my handwriting. I put an X there. That's what I do. This is my signature, which is dated at the time that Ms. Nitter was admitted to the facility. So that affidavit authenticates the document. The position of the plaintiff is that Ms. Nitter didn't sign. The position of the plaintiff is that it's a forgery, and the plaintiff carries that burden of proof. And I'll cite you back to the case I gave you earlier, the Alley case. One other thing before you let me go, the standard of review. It is clear in Tennessee that when a trial court denies a motion to compel arbitration, the review is de novo. There are at times mixed questions of law and fact. If the trial court reaches a finding of fact specifically, then it is due a presumption of correctness. The case that states that is the Rosenberg case. This is not an abuse of discretion standard. There is a presumption of correctness for factual findings. The problem we have is the trial court did not make a finding that Ms. Nitter did not sign the agreement. There's never been any proof presented other than lawyer argument that she did not sign the agreement, that someone else forged her signature.
All right, you don't dispute that that's Ms. Nitter's signature on the durable power of attorney, do you?
No, sir. I don't dispute that it's her signature on all the documents. It's my position. She was in a different place, a different time, under different circumstances. My signature would look different. In fact, if you look at all of the signatures she signed on all the many documents at the time of her admission to Quince, they're all a little different. I can imagine signing one, holding it above the lectern, signing one on the table. I mean, signatures will look different. And this was a moment when she's being admitted into a nursing home. So it is, this is a major life event. So it's not surprising to me that she's by herself, completely competent, that her signatures may look a little different. But my point
You
is,
said at a moment that she was being admitted to the nursing home.
Yes, sir.
Was she at the nursing home or in the hospital?
I don't know that, Your Honor.
Okay.
I don't know that information.
Okay.
Thank you, sir.
Thank you very much.
I want to thank the parties for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and ruling on this case within a reasonable